Hello, everybody. Back here today, doing the next segment in the Brendan Dassey state appellate appeal of the overturned conviction and the throwing out of Brendan's confession. This, as you know, I've been going over the state appellate brief and the argument for coercion. And this right here is the second case that I'm looking into of upheld confessions by the Seventh Circuit Court. The Seventh Circuit Court is obviously the court that will be hearing the appeal of Brendan's overturned conviction and thrown out confession. So that's why we're here looking at this. So the case we're talking about now is, we've already talked about Carter versus Thompson. This is the second one. This one here is Gilbert versus Merchant. It's actually, Merchant is actually the warden of the prison where he was when this appeal happened. The actual victim's name was Heard, Heard. Anyways, so what happened here in this case? This case is not really like Brendan's. It's really kind of not. It's very, very dissimilar. But we'll get into that in a second. This case against Gilbert, okay, had eyewitnesses. It had three specific eyewitnesses that were right there when it happened. So that's different. That's different because there is no eyewitnesses in the Teresa Halbach case. There's no witnesses. There's no blood. No sign that anything happened in the garage or in the house. Or in the trailer, I should say. So there's already huge differences between this case and Brendan's. But moving on. There's also in this case a fair amount of actual corroborative evidence that actually supports the storyline, and it actually corroborates Gilbert's confession. You guys may remember corroboration. Robert Milan, I made a video about him just the other day. And he talks about the corroboration of a confession. Well, this case has that. This case has corroborating evidence to corroborate the confession. Now, so what it ended up happening is that Gilbert eventually, after he confessed to the crime, he ended up getting convicted of it. And when he was in jail, he decided that his lawyer hadn't tried hard enough to get his confession thrown out when he went to trial. So, because of that, he felt that his rights weren't, observed or whatever, that he felt like his conviction should be overturned or something. But the fact of the matter is that in reading these briefs and all these legal documents about these confessions and coerced confessions and stuff, the fact is he didn't really object at all during the time that his trial was happening and stuff. He never once brought this up to his attorney at that point or anything like that. Also adding to that is that there was actually evidence. There's a totality of evidence here that kind of changes things. Even if they throw out his confession, and this is essentially this is a long summary of this case. Trust me. This guy, he was just desperately trying to get his confession thrown out, and he was trying very hard to do it, but it wouldn't work because the judges were looking at it going, okay, look, you didn't say anything at the time, but now you say that you weren't represented and you want the confession thrown out, and you think that by the confession being thrown out that it would have changed the outcome of the case. Well, that's not the case. The judges look at it and say, okay, even if we throw this confession out in the totality of all the evidence, he's still going to be guilty. There's eyewitnesses and physical evidence that tie him to this crime. So even throwing the confession out wouldn't help him, is essentially what they're getting at. But even then, they don't feel like throwing the confession out is proper because he didn't properly object to it, or he's not actually denying the confession. He's just saying that it should have been thrown out. The judges are like, what? Are you kidding? You just say it should have been thrown out, but you're not saying it was wrong, or, you know, you're not denying it, that's what happened or whatever, you know? So the judges just didn't like, you know, anything about what he was trying to do here. And like, rightfully so. I mean, the evidence against him was pretty significant. Even without the confession, he was probably getting convicted. Probably, I'm pretty sure, 90% chance that he was getting convicted, because like I said, physical evidence and eyewitnesses. His confession was kind of just a token after those things, really. So, anyways, that's what happened with this guy. I'm not going to go into a whole bunch of depth on this. I'm going to show you some of the documents here, just to kind of give you an idea of the, you know, that there was witnesses and what the court felt about his motion to try and get his confession thrown out and stuff like that. But I'm not going to go into it hugely, because, like I said, this case has no similarities to Brendan except for one. The only one similarity that this kid has, and I'm sure this is the only reason that his confession ever even had a chance, or why his habeas petition ever had a chance, was because his mother did show up to the police station at one point and was asking to see him, and she was refused. And the next thing she knows, she was being led out of Gilbert was being led out of an interrogation room and taken back into the holding area, the cell where the jail cells and stuff are. And that I think on that alone created enough doubt or issues for the habeas judge, the magistrate, whoever granted the habeas petition for him. I think that was enough for them to go ahead and give him the opportunity to go ahead and okay his habeas petition. But upon further review, it didn't hold up, because like I said, the totality of the evidence against him ended up just being too significant. And also the fact that he wasn't trying to deny the confession was true. He was just trying to say that his lawyer should have gotten it thrown out before the trial. So, anyways, it's just not exactly acting innocent, just acting like he wants to get out of jail. So, anyways, that's about it. I'm going to go ahead and show you guys some more documents here, and I may come back and say a few more words. Monica Collier was visiting relatives in the 8400 block of South Throop, and moments before the shooting had returned to her car to retrieve a radio and some cassette tapes. While walking to her car, she had observed several individuals she knew to be Blackstone gang members milling around on the sidewalk. As she was retrieving the tapes and radio from the car, two cars drove up and stopped next to her car. Collier saw Gilbert, who was carrying a crutch in his hand, walk up to the second of the two cars, point the crutch at the car, and call out, "That's folks," to the other gang members. That's basically just letting his other gang members know that he believes that the guy is from the rival gang. Collier ducked down and saw the two cars next to her speed off after the shots. So Lanier and Stringer, which are the two people in the first car, had noticed the approach. Had noticed someone approach, and heard someone call out, "Cap his ass." When they heard the two gunshots, they quickly drove off with Hurd behind them. Moments later, Lanier and Stringer noticed that Hurd was flashing his headlights at them. They pulled over, walked back to Hurd's car, and found him slumped over. Hurd had been shot in the back, and they took Hurd to the hospital, where he died later on that morning. So there's three witnesses that can attest to the fact that Gilbert was there. And if I lived in Wisconsin, this would be the political sign on my lawn around election time for the AG. Just saying. In the court's view, Gilbert's limited challenge of his confession did not call its voluntariness into question. The court noted that the voluntariness of a defendant's statement turns on the totality of circumstances, with the relevant factors including the defendant's age, education, intelligence, experience, and physical condition, the duration of the questioning, whether the defendant was advised of his constitutional rights, whether the defendant was threatened, enticed with promises, or coerced, and whether the defendant was induced to speak by police deception. For juveniles, additional considerations include the time of day during which the youth was questioned, and the presence or absence of a parent or other friendly adult. Gilbert had made no argument to any of these factors on appeal or in a lower court except the absence of his mother and his inability to speak with her during questioning, which he maintained was sufficient in and of itself to render his statement involuntary. In that regard, the appellate court observed Gilbert was wrong on the law. The absence of a parent during questioning of a juvenile does not automatically render the juvenile statement invalid, but rather is one factor that bears on the voluntariness of a statement. Basically, he didn't prove to the court that his statement was involuntary. He wasn't doing enough. He wasn't doing all the things necessary. So, all right. So there you go. That was essentially the pertinent information about this case. I, of course, will be leaving the link to the documents that I'm showing here. I will be leaving the link so you guys can go and read the summary of this appeal if you like. You can skim it or look for things that you are particularly interested in, whether or not looking at and stuff. Anyways, like I said, the link will be below in the information. You can just tell that this here confession was just not. It's not like Brendan's. It's just not. It's a whole different story. Like I said, just the corroborative evidence and witnesses alone make it night and day compared to Brendan's case. So I don't know. I don't understand exactly why Brad Schimmel, the idiot, would have included this case as like, basically to back up his stance that this court has upheld other confessions. Well, yeah, but this case only has one tiny thing in common with Brendan's, and that's that he wasn't allowed he didn't have an attorney or a friendly adult or a parent present. That's the only similarity. The one single similarity. Not enough. I can't believe he included it, honestly, but he did. Whatever. I just don't see it being very similar. So, anyways, the next one that we're going to be moving into, I believe, is Rubalcaba versus Chandler. I believe is the next case we'll be covering here. So I will be preparing that video. And I think there is going to be maybe a couple more videos. There's, I think, one after Rubalcaba versus Chandler. I believe there's one other upheld confession that was upheld by the Seventh Circuit Court, and then there's a one or two that were confessions that were deemed involuntary by the Seventh Circuit Court. So I'll be doing a video for each case, because otherwise, if I was trying to squeeze all those cases into one video, the video would be an hour and something long. Most likely it would be ridiculous. So it's probably better that we do it like this in short stints so that everybody doesn't get overwhelmed. Anyways, thank you very much for watching. Those are the next cases that I'm planning to do, and this is all in reference to the state's appellate brief regarding the overturning of Brendan Dassey's confession, overturning of his conviction and the throwing out of his confession. So that's what this is all about, just to reiterate. And like I said, there'll be a few more videos coming looking into this case law that Mr. Schimmel, the Shimmy Sham, has chose to include in his appellate brief as case law. So we'll be moving on to those other cases. If you haven't already, please hit subscribe, and thank you very much for watching.